The President yesterday filed with the Constitutional Court correspondence which set out his proposal of the resolution of the matter that comes before the court on the 9th of February, which is next week. That approach is consistent with what had been contained in the President's affidavit, wherein he sets out that he would adopt the findings of the public protector, and insofar as there needs to be a mechanism which needs to be created to determine what is the reasonable cost and consequently what would be the reasonable amount, if any, that the President ought then to pay. There has been no adverse finding made by the public protector that renders the President culpable on any matter. The President has always sought to implement a mechanism which would determine whether there is any amount that he ought to pay in respect of the security features that had been implemented at his residence. He has endeavoured to engage with the Minister of Police. He has allowed the parliamentary process to take its course, all of which so that he doesn't sit in judgment over what is in essence his own case. The proposal which sits before the Constitutional Court at the moment is an endeavour to bring about a mechanism using a Chapter 9 institution like the Auditor General, which would aid and assist, if the court deems it necessary, in determining what the audited expenditure was and what the audited contribution then would be that the President ought to pay. This has been a consistent approach the President has adopted, both when he complied with the Public Protector's directive that he must report within 14 days to Parliament. He set out in Parliament that he would compose a mechanism to determine those issues. Likewise, in filing his papers before the Constitutional Court in November of last year, 2015, he alluded to the fact that he is not at any stage failed to comply with the Public Protector's report. In those same papers that were filed, he set out and proposed to all the parties and to the court respectfully that the adoption of the use of the Auditor General, coupled with an official from National Treasury, would be the best independent persons that would be able to make such an adjudication. In the draft order that has been filed before court, and in terms of the proposal, the President will abide by whatever amount has been determined by the Auditor General and the Treasury official, and he commits himself to that payment. This is not a new approach that has been adopted. The President, both in answering questions in Parliament, coupled with his address, has always said he'll abide by a process. I think where the variance has been as to what that process must be and who would be engaged in that process. We've had various commentaries about the role that the Minister of Police has played, and so on and so forth. The indubitable facts is that as a consequence of the Public Protector's report, Cabinet has reviewed its policy and has adopted, in accordance with the proposal that have been made by the Public Protector, new measures to ensure that there's public accountability for the expenses that are incurred in respect of members of the Executive. Equally, the President, by proclamation through the SIU, has ensured that investigations would proceed. As a consequence of that, the civil claims have been brought against those parties who, in the judgment of the SIU, are culpable for payments that need to be made to the state. We've also seen various departmental inquiries that have ensued where the conduct of officials are being examined, also flowing from the Public Protector's report. And as I said, all of this was contained in the report which the President had submitted in accordance with the Public Protector's wish to Parliament, and these are the ongoing measures. So this intervention which the President seeks to make in the Constitutional Court is consistent with the approach that he has displayed, and it's an effort to bring about accountability and responsibility on the part of the Executive in respect of its conduct.